Hello, gym owners. Matthew Becker here from Gym Lawyers PLLC. Now, admittedly, the majority of the work that we do with gym owners typically happens with new gym owners who are just looking to start a gym and established gym owners who are looking to sell or buy their gyms. Okay? It's those gym owners in the middle, what we really like to refer to as the established gym owners, that typically don't reach out to us. But here are the 6 reasons why they should. Okay. Number 1, determining whether or not they have filed their fictitious name properly with their own state. Right? And we've done a number of videos on LLCs and why you need to file your LLC and then why you need to file your fictitious name. But a fictitious name is the actual name of your business, your branding name of your business, right? So if you're a CrossFit gym, you may have an LLC filed as My Gym LLC, but you operate the gym as the Sweatshop. That Sweatshop is a fictitious name, a doing business as, a DBA, a trade name, whatever your state calls it. If your state requires you to file your fictitious name or register it and you don't, you personally are now legally exposed if there's ever any problem. Okay, you have to file that if your state requires you to do that. So that's issue number 1. Issue number 2 is not having an operating agreement. Established gym owners who don't have operating agreements often don't see the need to have an operating agreement. And the problem there is, 1, you're missing a big piece of proving legally the legitimacy of your LLC. And 2, you're missing a big opportunity to make sure that your company continues to run and to dictate how it's going to run if anything ever happens to you and you become incapacitated or, worst case, you die. Number 3, the third reason that even as an established gym, you need to contact one of our attorneys at Gym Lawyers PLLC. Reason number 3 is bad language or inefficient language in your waiver. The established gyms that have reached out to us and just asked us to review their waiver, we've often found 9 times out of 10 that there's problems in the waiver. Either it's missing necessary language, it has unnecessary language, okay? Or it's just completely out there with stuff that doesn't even matter, okay? For example, we've reviewed waivers before that have references to climbing walls in the waiver. Why? Because this gym owner took the form offline and just adapted it and used it and has been using it for 2 years with their members, when if there was ever a problem, all of this language in here just nullifies the waiver because it doesn't even apply, let alone the fact that there was missing a significant amount of language. All right, issue number 4, membership contracts. So part of the problem here is that we often see waivers and membership contracts combined into one document. Now that has its own issues, and we'll probably do another video on that. But you need to have a written membership contract in order to avoid being sued when a disgruntled member comes back and says, I want my money back. I didn't use the service didn't work for me, I've paid for 3 months, but I've only come a couple of times, now give me the rest of my money back. All of this stuff can be protected against if you have a written membership contract. Where are we at here? Number 5, right? Number 5, employee contracts. Right? Whether you have employees or whether you have independent contractors, you need these expectations put in writing so everybody's on the same page. Whether or not you can protect yourself with a non-compete clause is another topic. You could have non-solicitation clauses in your membership contracts. Expectations like, what is the hourly rate? Are there any incentives? Right? What conduct is going to constitute you firing the employee or letting go of the independent contractor? And finally, number 6, the 6th reason why, as an established gym owner, you need to reach out to somebody like us just to do a legal checkup on all of your legal documents. Laws change. Every year, states update and change their laws. You may have a perfectly good waiver or a perfectly good membership contract that would have protected you 2 years ago. But last year, your state changed the laws. And because of that, your documents no longer protect you. Right? California is a great example of this. Recently, they changed their employment laws to say that employers or owners of businesses had to provide their staff with benefits. Well, now, according to the IRS, they can no longer be independent contractors. So all of those independent contractors that used to be in California now have to be employees because there's been an update with state law. For whatever reason, as an established gym owner, that you feel like you may have some questions for an attorney, reach out to us. We love doing legal checkups to make sure that we fill all of the holes to make sure that you are not legally exposed.